Good afternoon, folks. Welcome to immigration.com, Law Offices of Rajiv Khana PC, community conference calls held every Thursday, once on LinkedIn Audio and once on our personal conference call bridge. I am Rajiv. Today is June 1st, 2023. All conversations here, all advice here is subject to the disclaimers you heard when you were logging in. So no attorney-client relationship, information as is. We do the best we can with what we have. Okay. So as usual, I would normally address the frequently asked questions that are marked in our forums first, and then I would go to the posted questions that are not frequently asked questions. And every step of the way, I would open the conversation to people if they have any follow-up questions. No new questions at this point. Once we finish going over the posted questions, then we open the call to all questions that are still left over. So that's the time you can ask your new questions. At around 1 o'clock Eastern Standard Time, I will lock the conference so whoever is here is assured that I'll be able to give them an answer to their question. Okay. With that choreography in mind, let's first of all make sure you guys can hear me. 1 second.
The conference is now in conversation mode.
Can you all hear me okay, guys? Can you hear me?
Yeah,
Okay.
yeah, we can.
Excellent.
The conference is now in presentation mode.
Okay, so the first posted question on our forums, forums.immigration.com, a revoked H-1B never went for stamping. Is gap exempt possible? Had my H-1B approved in 2019, revoked in 2022, employer is not responding to my email, so I don't know what's going on, never went for stamping, did not have approval notice, all I have is a case receipt number. Can another employer do a gap exempt? So there is a difference between what the USCIS says and what they do. Typically, they say if you don't have a change of status or if you don't have a visa stamp, we still consider you to be subject to the lottery. As a practical matter, we have done several cases like yours. The second issue is I don't have the approval notice, I just have the receipt number. You can try. It's very difficult for me to predict which way it's going to go. But other than the money that you spend in filing or your employer spends in filing the case, I think it might be worth a shot. Is it a clear-cut yes or no answer? It is not. *5. If you have a follow-up question on this, no new questions, press *5 on your phone if you have a follow-up question. Okay. Moving on to the next question, L2 to EB2 visa, L2 to EB2, okay. Managing status, backup plans, and options during green card processing. I'm currently in L2 until 2024. Employer is sponsoring green card, filed a PERM based upon the current processing time, take around 10 months. Okay, so I will have 3 months to file the 485. You've done some very precise calculations. Don't depend upon them because you can't really predict things to this mathematical certainty. As a backup plan, is a good idea to apply for an F1 status? Yeah, I think so, because you should maintain your status. Can I utilize section 245K? Yes, you can. And can you work without authorization? Again, theoretically, yes, you can. But here is the problem. Despite 245K, what I worry about is if there is a smart USCIS officer and they find you doing things that are deliberately violative of the law, they can discretionarily deny your I-485. Remember, I-485 is a discretionary application. It is totally upon the discretion of the USCIS. If they look at your conduct overall, they could always say, well, we don't accept this person as a good case for adjustment of status. They should go through consular processing. So I don't advise that. Can I change to B1, B2? Yeah, you can. You can certainly try. And then Section 245K offers you good protection, because even if your case remains pending for a few months, as long as it's less than 180 days, you can file the 485 whenever the dates become current. And then 245K makes sense. And if you go to my blog on immigration.com, we have written an article on how to convert to B1, B2 when you've lost your H-1B job. For somebody like you, it's exactly the same idea and the same application. All the criteria there would apply. Okay. *5 if you have a follow-up question. No new question. Press *5 on your phone for follow-up questions. Okay. Moving on to question number 4. Closing an EB3 I-485 application. Implications for permanent residents with multiple concurrent filings. I applied for 2 I-485s, EB2 and EB3, in October 2020, as I had I-140s in both categories. Received my green card from EB2. EB3 I-485 is still open, and a few people in my situation, October 2022, mess of sudden priority date movement, had their own I-485s administratively closed. Should I call USCIS to administratively close? Okay, as long as you know that your approval is absolutely on the up and up and there are no questions about it, I don't see any problem in closing the case, but let your lawyers help you decide. There is some advantage in leaving the case open and letting the government close it instead of you reaching out if there is any issue with your current green card approval. So in other words, let your lawyers help you decide whether or not you should close the second case. It's going to go away anyway without you doing anything. They are not going to issue you 2 green cards. That does not happen. Okay. So if it's on the up and up, everything is good, go ahead and close it. Otherwise, let the government close it. *5 if you have a follow-up question. No new questions. Any follow-up questions, press *5. This is the question number 5. Using prior employment experience for PERM after returning to former employer. I left an employer, joined back again after a few months. Can I use my experience gained with that employer? No. Unless the job offered in the future is substantially different, so you can't use that experience. I don't see how you can. Okay. *5 if you have a follow-up question, press *5. But remember, the future job can be quite different from the present job. Then you can use all the experience that you have, even though it's with the same employer. Question number 6. Managing H-1B extension, marriage and travel plans with pending 130, 485 and I-765. So the question here is, I'm currently on an H-1B extension expiring in November of this year. Employer started the PERM process. I-140 approval might come early next year. My employer is willing to file an amendment to recapture 4 months I've spent outside. This extends my H-1B to end of February. Okay, I'm not going to bother with the dates. I'm just looking at the big picture. My fiance is a green card holder and has a naturalization interview scheduled for June 15. By the way, this month your dates are current. If you wanted to get married this month, you could file a 485. Okay. So would getting married before her naturalization impact her path to citizenship? No, not at all. Does she need to do anything before the interview? She just has to inform the, I would actually make a call to the USCIS customer service, let them know that one thing has changed, which is now I am married, and the N400 should be reflected to update that. And then when she goes for the interview for naturalization, she should point out to the officer, look, I'm married now. They might make the changes. But even if they don't, it's not a big deal. The way I look at it, as long as your paperwork was true and correct on the date it was filed, if later on something changes, it should not be a big problem. Can we file I-130, 134, 765, 485 concurrently this month? Yes, I already said that. My fiancé and I would like to travel to our home country mid-October. Don't plan that if you are going to file a green card now. If you have an H-1B visa, you can travel. Otherwise, I would be hesitant in sending anybody out in this environment. And try to travel on a 131 advanced parole. Don't try to travel on an H-1B if you can avoid it. Okay, I just think that's a bad idea. *5. If you have a follow-up question on this, press *5. Okay. Going on to question number 7. Moving to India after obtaining a green card or citizenship. Well, if you move after getting a citizenship, there's no consequence because citizens can stay away from USA as long as they like. Green card holders cannot. After receiving green card via EB-123 route, how soon can I permanently move to India without losing green card status? Well, that's a complicated question. Bottom line is, if you choose to abandon your green card and leave, your green card is gone even after 1 day's absence. It's a matter of intention. If on the other hand, you go for less than 6 months, that's not a problem. If you go for more than 6 months, you will be very carefully scrutinized upon your return, whether you in fact have a permanent home in the US or not. And if you're gone for a year, your green card is automatically canceled. Okay. *5, if you have a follow-up question, press *5. All right, let's move on to the next question. Maintaining status and avoiding disruptions, utilizing change of status to B2 as a bridge during H-1B max out. Time has been recaptured, PERM was filed. Like to avoid going back to India. Can I buy times to stay by filing change of status? Yes. Yes, I have answered this question in a different context. So if you go to our blog and look at the, I think it's the first or second entry that talks about applying for B1, B2 if you're looking for a job and your H-161 days have expired. It's the same principle that would apply to you. Okay. *5, if you have a follow-up question, press *5. All right. This one is from Ohio. Ohio, go ahead. I can hear you. Yeah, go ahead.
Hi. I am in India and I applied for B2 to get back. I lost my job while I was an H-1B. I came down to India and I lost the job. I applied for B2, but my visa got rejected. So should I apply again? Or should I wait 6%?
I think it's a weak case for a B2. You can try again. There's no harm in it as long as you state the truth. But coming back on H-1B might be a better option for you, sir. Okay.
Okay, but the job conditions are very bad.
Yeah, you have to look for a job, get a transfer filed, get the transfer approved. And if you have a visa on your passport already, you can travel with the new approval and the old visa. Otherwise, if you don't have a visa, go get a visa stamp after the transfer is approved. Okay?
Okay.
Good luck.
Okay. Thank you.
All right. Bye-bye.
Thank you.
You're welcome. Okay, next question is question number 9. Filing a lawsuit against the State Department for visa bulletin retrogression. Oh, I don't know about this. I don't have too many insights on this simply because we've not been involved in these litigations for a while now. We just don't have the time. You may want to check with law firms that are doing litigation as a full-time job. We are not. We are focused strictly on our transactional practice right now. Last year we did a lot of litigations. Not last year, during Trump administration. Okay, so no comments on this. Sorry. And it's a little difficult to make these cases, but I don't think anybody in the recent past has won any of these cases, but who knows. EB-2NIW, employer's involvement. Since EB-2NIW is self-sponsored, is it okay for my employer's lawyer to file the petition? Sure. Why not? Can my employer pay for my EB-2NIW? Absolutely. If they want to. No harm. *5, if you have a follow-up question. The only thing I would recommend is that the case be filed in your name, not in the employer's name. So there's a question from New York. New York, go ahead.
Hi, Rajiv. Thank you. So I'm actually using an independent external lawyer to put up my case together.
Right.
And I only want my current employer to pay for the USCIS and premium processing fee because the lawyer fees has already been taken care of by me.
Okay.
And given my employer is already going through this regular EB2 process and they are actually filing for the putting up the recruitment process and whatnot online. I don't know if it is worth taking that risk and putting this forward in front of them that, hey, this is everything and you just have to pay and proceed.
I see. Here is the problem. I think there is a little bit of a discordance between filing an NIW and filing a PERM application at the same time. So this should be coordinated. This should not be done without coordination between the two lawyers, the one doing the PERM and the one doing the NIW. Because part of the NIW is an assertion, give me a waiver because I can't file a labor cert for this job. Okay. So I think that needs to be coordinated. That's the first important thing. As far as payment is concerned, can the employer pay? Sure. Are they required to pay? No.
Yeah, they're not required to pay. That's for sure. Because for the regular one, they're required to pay. So
absolutely.
Because some people say that you should actually silently work in the background and let your NIW approve and let the employer go through the normal process as well. So I was like, I'm not.
I am not. See, NIWs are usually a lot easier to predict than EB1s. I mean, we can look at the case and kind of guess that it's going to work or not going to work. But EB1s are very difficult to predict. I would want your two lawyers to talk just to make sure you're not doing something that's mutually controversial.
Okay.
All right. Good luck.
Thank you.
You're welcome. Okay. Next question is number 11. Exploring options for H-1B expiration, considerations for B2 visa, H-1B extension, alternative paths. H-1B is expiring June this year. Project will end. I'm still under my employer's W-2. They'll pay me 1-2 months more. Looking for new projects. Should I file a B2 as a backup option? Yeah, of course. And as I mentioned earlier in this conversation, you can go to our blog on immigration.com and look at the entry we have. It's the first or the second entry on how to apply B2 if you can't find a job in 60 days after a layoff. It's the same principle that applies to anyone for trying to get in B1, B2 to maintain status while they are waiting for something else to happen. So all of these questions are answered there actually. Yeah, all of these are answered. If dependent visa is not an option, student visa is, so you can look at that as well. Those are the two, B1, B2 and student visa, I would say. Star 5, if you have a follow-up question, press star 5. Okay. We are pretty much close to the end of our posted questions. Soon I'll lock the conference and then we can make sure that everybody who has any questions gets their answers. Taking a break from employment with a pending I-485 implications, AP expiration and returning on H-1B. Dates are not becoming current, planning to take a break for 6 months to 1 year, then start again. Oh yeah, there are many implications. You need to talk to your lawyers, make sure the employer has an ability to pay, make sure that even if you are not working, you can establish your intent to continue, make sure that your lawyers advise you about whether the job is still available. So your willingness, the job being available, ability to pay wages, these are the three issues I can see right away. If I go out and don't return before my advance parole expires, and then I get an H-1B and come back, will it be fine? I think it'll be an abandonment because there is a gap between the AP expiration and the H-1B approval. I'm not sure that's okay. All right. I'll have to look at the law very carefully from this minuscule angle. But my first instinct is to say that may not be okay. Have that research. *5, if you have a follow-up question on this, press *5. This is from, let's see, there are two questions. First one is from Pittsburgh. This is Kansas. Okay. One second. I got this confused. Yeah, 620 area code 620. 620, go ahead, please.
Hi, Rajiv. Good afternoon. Just a follow-up question on H-1B, B2 visa. For instance, if my I-94 is expiring in June, and if my employer is applying for an H-1B extension, and for any reason, if the extension is denied, should I file like a B2 visa as a backup option?
You can. So let's say that your H-1B is expiring on June 20th. If your B2 is received by the USCIS on June 19th, before the current H-1B expires, it's a good backup in case the H-1B extension is denied.
Okay, but in the same, on the other hand, let's say if my employer is also filing an H-1B before June 19th, so can I do two applications? Can my employer file my H-1B extension at the same time?
Yeah. Whichever is approved last will be your status. So that means file your H-1B premium processing and then withdraw your B1, B2 as soon as your H-1B is approved.
Okay, got it. Yeah, so I think that makes sense.
Yep.
Okay, thanks.
Good luck. Next question looks like it's from New Jersey. Okay. New Jersey, I can hear you. Go ahead, please.
Hey, Raju. Yeah, this is, so I'm, that question for 45 implication for leaving the country that I have posted. So,
right.
So
right.
say, as you say, if there is a gap between AP expiration and H-1B, then it might be abandonment.
Yeah, that's my guess. That's my common sense, legal common sense guess. Law can be forever surprising. You never know. You think the law is going to be something and it turns out to be something else. I would want you to have this researched, but my first instinct is to say, yeah, that would be a problem. Go ahead, sir.
So in say I have AP, as long as I have AP, I go out, I leave my current job and then come back on AP and then start a new job. Then still it will be like that 6, 7 months or 8 months, whatever.
Yeah,
I will not be paid or I will not.
That should be okay. But the only recommendation I have for you, before you return, get your supplement J filed through a new employer, so that's pending when you return. That way, if the Customs and Border Protection says, "Hey, why are you coming back if you don't have a job?" you can say, "I have a second job. My supplement J is pending."
Okay. Perfect.
That would be the
so
right
basically
thing.
Get a backup plan.
You could stay in India as long as your advance parole is valid, 1 year, 1.5 years, no problem.
Okay.
All right.
Thank you very much.
You're welcome, sir. Good luck. Okay, moving on to what I think is the second last question. Yeah, we have 2 more questions. Let's see. Taking a break. Next question was, traveling while green card is pending. Want your help with the current scenario. Husband filed for EB1, got the approval. Congratulations. We filed for adjustment of status this year, completed biometrics. Advance parole is taking close to 18 months. Yes, it is. Once we have our travel document, can we travel to Mexico or other countries that typically accept US visa? So I'm not a lawyer who practices on the Mexican side, so I can't answer this question authoritatively. You're going to have to check with lawyers on that side or the Mexican consulates. But advance parole is, from the US side, is definitely accepted as a travel document. Can we travel outside the country while the adjustment is pending, even if we don't get our AP documents? You can travel on your H-1B visa, But when you return, you'll have to refile your advance parole. Okay. I think that those are the only questions you had. *5, if you have a follow-up question on this, press *5. Okay. Let me move on to our last question. Then I'll lock the conference and just, oh, somebody from Georgia. Oh, there's another call, another person who, okay. Let's start with Georgia first. Georgia, go ahead, please. Area code 469, did I get that right? Okay. Let me try again. Hang on. No, this was from, yeah, area code 469 should be unmuted. So guys, I remind...
my name is Madhu.
Yeah, Madhu, 1 second. No new questions at this time. Only follow up on what I discussed. If anybody has a new question, press *5 and put your hand down. That's not at this time. Okay, no new questions right now. Press *5 and put your hand down. Madhu, did you have a new question or a follow-up? Okay, so I'm going to put that down. Then there is somebody from area code, let's see, this is Ohio, I think. No, 614, yeah. Ohio, did you have a follow-up question? Go ahead, please.
Hi, Rajiv. Not a follow-up question.
No, then put your hand down. Wait until I ask for new questions. Area code 832, which is Texas. 832, Texas, do you have a follow-up question? Go ahead.
Sir, it's on traveling on advanced payroll. So it's same question, I think.
Just wait. If it's not exactly related, I'm going to get back to it. So I'm going to cover everybody's questions anyway, so just hold on. Okay, so please ask me only questions that are directly related to what I just discussed. Okay, then the last question we have today is eligibility and restrictions for income and business ventures on H-1B and H-4 EAD. I've covered this question 50,000 times. Just read our frequently asked questions, please, on immigration.com. I'm not going to go into it again. Please sharpen the question. After you've read the FAQ, if you still have questions, I'll be happy to deal with them. If you are here, press *5. I can answer 1 or 2 pressing questions. Otherwise, just read the frequently asked questions. Okay, let me lock our conference first of all.
The conference is now locked.
All right. Anybody who has any question, press *5, please. Anybody who has any question, press *5. I'm going to unmute you in the order that you logged in. The earliest person first. So far I have only 9 questions. 9 questions. Nobody else? Is that it? Okay. So let's start with Illinois, which is going to be, 1 second, sir. Illinois is going to be area code 815. Let me find you where you are. There you are. Okay, 815, I can hear you. Go ahead, please.
Yeah, hi Rajiv. I wanted to ask what's the procedure if someone is on F1 visa, currently working on STEM OPT, and they want to get transferred to an L2 visa, L2 work visa?
Well, you have 2 options. One is to just apply for a change of status. Okay. The other one is just take a flight to Mexico or Canada and get your visa stamp and come back.
Okay, and then I can continue with my current employer, or do I have to apply for EAD?
No. No, you don't have to apply for an EAD. Just when you return with an L2, you can immediately start working.
Okay. And my last question was, Rajivji, what, like, during the H1 registration, does the verbal job offer count, or if there is a scrutiny, does the verbal offer count during just registration if the petition was not filed?
I'm not sure what that means. I'm not sure
I mean,
what you're
if
asking.
this year, if since there has been a lot of scrutiny this year, and if in case a person has filed from a consultancy and they have applied from two jobs, one is the real and one is from a consultancy, and if the consultancy one was just a verbal offer, and if in case his H-1B gets picked next year and he files for a petition, then in the scrutiny can, like, will the USCIS check, like, will they ask that was it a verbal offer or
without, for an offer is an offer. Well, first of all, let's just be very accurate with our language. Verbal means words which can be written or oral. If you mean oral, that's probably what you mean, because verbal can be written or oral, which means of words. If it is oral, it's still an offer. I don't know what that means. I don't really understand what you're asking me. But if there are multiple lottery filings, can they come back to haunt you in the subsequent years? They can, but it's unlikely that USCIS is going to go after individuals in the following year. That would be my guess. Okay?
Okay.
Good luck.
Thank you.
You're welcome. So I have 10 more questions now. A couple of people changed their mind. Okay. So now I'm going to go to, this looks like Canada. No, California. Why did I think Canada? 818. Let's see. Where is 818? I'm going in the order in which you guys called in. Okay. Yeah, 818. Go ahead. I can hear you.
Hi, Rajiv. I have a PD in EB to India from 2011 that was current for more than a year.
Achha.
Currently, it is not current. So my attorney is recommending that we file our H1 extension to get a 3-year full extension. So I wanted to get your kind of second opinion. Is it at this time risk-free, or should I prepare to leave country as well if an extension gets denied?
Listen. What you're asking me, let me paraphrase that in the words of Arjuna and Krishna. So Arjuna says, can we just go home and not fight this Mahabharata thing? Because I'm going to lose anyway. And Krishna says, wait, hey dude, at least fight it. You always have the option of going home, right? So the point is, at least try it. You might be able to make a convincing case for an extension without having to leave. If you leave without even asking for it, how would you know what would happen if you asked for it? So definitely apply. You have a good reason. By all means, establish it. I actually just sent out a case for a litigation last week where something similar happened and the government denied my H-1B extension, and I know they are wrong. Okay? Because that case is particularly unique. So let your lawyers advise you. At least try. That would be my recommendation. Okay?
Got it. In my case, they do have circumstances out of our control because
there you
still
go.
Processing with.
There you go. Yeah. Extraordinary circumstances beyond your control. And if they try to deny you, just sue.
Got it. Thank you.
Anytime.
And there is another. Can I ask one more question on as a follow-on on this one? I do have a possibility of converting to EB1 by being outside for 1 year.
Yeah, but hang on. Your priority date is 2011, right?
Right.
What is the priority date right now?
For EB2 India, it is January 2011. Mine is March, so I'm 2 months.
Yeah, I think you may not have to do all that. So stick on for till the end of this fiscal year. Let's see what happens. Okay.
My PERM was recently denied. I have to start from fresh again. Prevailing wage, we kind of appealed and it got denied again because. So it's just a wait game now. Whether we should go all the way start from scratch.
I don't think there is a particularly strong legal indicator either to stay or to go. I think they are both pretty good. Okay. If I were you, I would probably go. Why? Because EB1C is such a strong case, it's difficult to deny those cases. In the meantime, the EB2 can still go on in your absence, no problem.
Got it.
Okay.
So if it becomes current and my new PERM comes sooner, then I can always come back.
You can always come back. Absolutely. All right.
So last question. If I choose the EB1C, so I have to be 100% outside country for one straight year. Can I come in between on the
look, I say count 366 days. If you come to USA for 10 days, then you've got to do 376 days.
Understood.
All right.
Got it.
Good luck.
It is allowed just in the counter.
Yeah, you just have to do the extra time then.
Got it. Right. Thank you again, Rajiv. Very helpful.
You're welcome. Good luck, sir. Okay, let me see who's next. Next one is Ohio. Ohio is, what area code are you? 937. 937. There, I see you. Ohio, go ahead, please.
Hi, Rajiv. I have a question. So I just filed for I-29 for my H1. Actually, I'm in my F1 STEM OPT. It's going to end in October. So now my H1 is processing. I also got an admission for PhD from the same university which I graduated my master's. So my DSO says I cannot start my PhD from fall. She says you can start whenever your H1 starts. I mean, that's from Jan. So is it true, or we can start from fall?
I think there is a restriction against people. Are you on STEM OPT?
Yeah, 2 years STEM OPT.
Yeah, I think there is a restriction on STEM OPT people going to school at the same time. Yeah, I don't know how much that restriction is. I don't know off the top of my head whether you can't take even one course, but there's definitely something in the law. I don't remember off the top of my head. So how can you double check it? Call another DSO in another school. Okay.
Okay.
Good luck.
One follow-up with this is like, since I'm not allowed to work or do anything which can generate a revenue in H1, which I am not able to fund for my PhD, and I have to give from my pocket. So my professor offers like you can just work for me, where he get funding, and he's willing to pay the fees. So is that okay or not?
So hang on, let me try to understand this. It may be possible for you to do an H-1B through your university. Is that what you're saying?
That's a concurrent. I'm not sure whether the university will allow the concurrent.
Okay, no. Wait. Concurrent, what does concurrent mean? I mean, you are currently on H-1B.
I already have a H1.
Yeah, you are currently on H-1B, but you're planning to quit that and go to school full time, right?
No. I'm continuing my PhD and my job.
So you are going to stay on H-1B. Hang on. You're going to stay on H-1B and study at the same time, right?
Right.
So here is another option. Hang on. Let me finish. Here is another option. The option is, if you can and you want to, you can quit your current job, but you said you need to fund your education, but you have a job, right?
Yeah, I have a job. Instead of paying from my pocket, my professor offers
then you have to do a concurrent H-1B. There is no other option.
Okay. Right. Even he can't, just pay because of my research?
We can't pay they can't pay you without some kind of work authorization. Okay. Can they pay you a stipend hang on. Can they pay you as a stipend? I don't think you can take it on an H-1B. You might have been able to take it on an F1. That's my guess.
Right. Okay.
Good luck. All right, let's go on to area code 614. That's Ohio. 614, Ohio. Ohio, go ahead. I can hear you.
Hello, Rajiv, sir.
Hello, sir.
I work for a company which is situated in Michigan, and I reside in Ohio. I mean, the H-1B was applied by the company when I was in Ohio. Now, I also have a residence in Michigan. However, I still have the Ohio residence valid, and my deal and everything is attached to Ohio residence. Now, I don't want to file an H-1B amendment at this moment for a location change because my wife is on F1 and she is working to get her employer to lottery next year. And she doesn't want to change her status at this moment because the employer is not informed about the visas and just to avoid confusions.
All right.
And her F1 visa is valid till September 2024.
All right.
Now, my question is, can I file my H-1B amendment later, maybe 6 months down the line, since I have Ohio residence still valid?
Okay, so hold on. It's a very simple decision. Wherever you work from, that's what should be reflected in your H-1B. This is not a question of artificial considerations. Well, I have a home there, but I live here. No. Wherever you sit down, that's where you must have an H-1B. And remember, you can add... Hang on.
But the thing is, I did not have this residence until last week.
Okay.
I was like traveling and staying in hotels for 5 days and coming back to residence in weekends. So
still the same rule.
Was conveyed
still
to
the
my
same
employer
rule.
also.
If it's a peripatetic employment, that's what you're talking about. If it is a peripatetic employment, you still have to have a home office, and it's the home office that's your location, even if you're traveling 5 days and coming back over the weekends. I'm making a guess here. Your lawyer should be looking at your H-1B to make this decision. But wherever you are actually sitting, and even if it is over the weekend, that is your location. Okay? Because the law says peripatetic employees can travel as long as the travel is not, I think it's what, more than 5 consecutive days, something like that. And they have to have a permanent. So check this out. Just do a Google search on peripatetic employment, peripatetic H-1B.
Okay.
Whatever those regulations are. What I'm thinking the way out for you is to do an H-1B that covers both locations. So just do an amendment. And this time the amendment will say, I live in Ohio and Michigan both.
Right. I have no issues if I file for Michigan location also, but the reason I want to wait is to cover my wife also at later sometime, because she doesn't want to confuse her employer about the visa change F1 to H-4 EAD, and that's the reason I'm waiting. So I want to do it at a later time.
What you're thinking is, are you thinking of bundling the applications?
Yes. So
okay.
Whenever
H1, H4, H1, H4, H4 EAD.
H4 to H4 EAD.
Yeah, but you're not going to help anybody by falling out of status because of a location not being covered by your H1B. So I don't think you are applying the right remedy to the problem. You can always worry about how to do an amendment later on, but I think you should never ever have a situation where you are not covering a location where actually you are working from. Your lawyer should sit with you. This is a more complicated decision because of the peripatetic employment. Okay?
Okay.
So,
but let's say if I do it now and later, 6 months later, if I want to include my wife for a change of status.
You have to think of a way to do it. One of the ways could be if there's a salary change, a job change, title change, job description change, you can file an amendment. Okay.
Okay. And I have another question.
I'm going to have to cut you out because, look, I have a limited amount of time. If you have a 10-second question, I'll answer it. Otherwise, I've got to move on.
5-second question.
You got it.
What kind of evidence they look for the trade publication? Like for applying for EB1, there is the criteria. They're looking for something. Publish your work in a major trade publication. What kind of evidence they look for?
You have to prove that it's a major trade publication, and majority depends upon the circulation figures. Okay.
I see. But what kind of article or something they would consider it? Because my work has been published in many reviews.
See,
because
a scholarly publication is a publication that's written for scholarly audience. Okay, so even though, let's say I publish an article which is very technical for lawyers in Washington Post, even though Washington Post is not a trade publication, this might count because the audience for my article is lawyers. It's a little.
So I am a mechanical engineer, and my work is related to automotive industry.
Yeah. So again, the answer is it depends. Whether it's a major publication or not depends upon the circulation. Not a question I can answer yes and no. You have to look at the circulation figures. Talk to the publisher; they can tell you. Okay.
Okay.
Good luck. You're welcome. Okay, yeah, guys, I have a little bit of a limited time here, so I try to cover as many people as I can. Prioritize your questions. We have 6 more questions left. The next one is from Texas, area code 469. 469. 469, I can hear you. Go ahead, please.
Hi, I have a question. So my fiance, he's in India currently with existing H1 approved stamp. Can he come to US without client letter and look for a job here?
No. If he does not have a job, okay, traveling to the United States could become problematic for him. What if the Customs and Border Protection says, wait a minute, economy is tanking, we have to call your employer to make sure they have a job for you. And the employer says, no, we don't have a job for him. You could have a problem. So I would be careful with that.
Okay.
Am I being paranoid? Yeah, but I was an immigrant myself. So I'm very careful with what I do, not only as a lawyer, but also as a past immigrant. So I would be careful. I think it should be avoided. Okay.
Okay. He was working for a client, First Republic Bank, and then that got taken over by JP Morgan. So there is a delay because of that. So not sure when he'll be coming. So if I have one follow-up question. If he changes the company with his current H1 approved with company A, does he have to get H1 approved again or transfer with company B?
Every time you change companies, you have to do an H-1B transfer. Okay.
And then stamping as well?
No, the same stamping can work.
Again?
The same stamping is okay.
Okay.
All right.
And can he come over? Sorry, you were saying something?
Yeah, I'm trying to just hurry you along. What else do you have?
Just one. Can he come here on H4 and look for job using his current approved H1?
No. Wait. There, one part of your question is a good question. The other part of the question doesn't make sense. So once he converts to H4, he no longer has an H-1B. But once he finds a job, he can convert back to H-1B without worrying about the lottery.
Okay.
All right. So he's not looking for a job on H-1B. He's looking for a job on H-4, but he's eligible to convert to an H-1B without lottery. All right.
Okay, but does he have to go back to India for stamping?
No, he can do a transfer. He can do a transfer here.
Oh, so for that EAD is not needed. He can, but he still need the EAD.
He can't work.
EAD.
He can't start working until the H-1B is approved.
Okay.
All right. Ma'am, I've got to move on. Good luck. Okay, now Who's next? Let's see. This one also is Texas. This is 469. Let us see. 469. Okay, 469, I can hear you. Go ahead, please.
Yes. Hello, Rajiv sir. If my H-1B petition gets denied, can I get back to my F1 visa? And I still have 3 years of OPT left.
Okay, so the way this works is, I'm assuming you are currently on OPT first year.
Yes, my EAD is yet to approve and come.
Okay. So what happens is, when you apply for H-1B change of status, your DSO will suspend your service. So you are now in gap, but your service is suspended. Although actually, hang on 1 second. I'm sorry, I'm wrong. This may not happen in your case because your EAD is not even here. You are still on first year of OPT, right? About to get on to first year of OPT.
Right.
Okay, so the answer is yes. If the H-1B is denied, you continue to be on OPT. If for some reason, I don't think it should be, I see no reason for them to suspend your service. If they do suspend your service, you can just go back to the DSO, show them the proof of denial. They will reinstate your service and you go right back to OPT and continue working.
Okay, sir. Thanks, Rajiv, sir.
You're welcome.
And what is the benefit of like employer filing H-1B petition in a premium, like apart from that early result?
Well, you just know the result early, although the non-premium has not been too bad. Couple of months, 2-3 months. So, up to you.
Okay, sure.
All
Thank
right.
you, Rajiv, sir.
You're welcome. We have 4 more questions. Let's go to, which one is this? Area code. Okay. This is New York, 917. Let me find you, sir. 1 second, or ma'am. Okay, area code 917. I can hear you.
Hi, Rajiv ji. I do have questions on proving the intention.
Mm-hmm.
So many times in your, speaker sessions, you have mentioned that as long as you have the intention to do X, Y, Z, you should be okay.
Mm-hmm.
For example, like if PERM I-40 is pending and you are on another location, if it is proved and you have the intention to go back, it's all good. So how do you prove that intention? Because it's a feeling, it's an ethic, right? What's a documented proof?
That's a very good question. And I actually, coincidentally, I just discussed that this morning with an employee who had to leave USA to go back to India to take care of his parents. So his employer, he and I were talking. So he wanted to know, first of all, can the green card go on because he's been called for an interview at the consulate? Can the green card still go on because he's not worked for 2 years? And my answer was, this is the way it works. When you enter the United States, after getting your green card, it should be your intention to work for your employer who sponsored you on an indefinite basis. You should have no intention of leaving them. Okay. And I'm saying intention. I'll show you what it means. So I said, think about the intention of a person who actually wants to come and work in Texas. Okay. He goes to Texas, he takes the plane, he lands in Texas. He maybe puts up with a friend or family or a hotel for a couple of weeks. Then he finds an apartment. And in the meantime, he's reported to duty. He might even have started working. And he converts his license. He gets his children into schools in Texas. And he converts his driver's license, opens a bank account. And then 3 days later, Satya Narala calls him, says, we really need you. Forget about it. We'll triple your salary. Come join. Is that person going to lose their green card if they join 3 days after they got their green card? No. Why? Because it was never their intention to leave when they entered the United States and when they reported for duty. How is intention to be determined? Intention is determined by circumstantial evidence. What are the circumstances? Is this guy behaving like he wants to stay here? Take the second example. Same guy, he comes and stays in a hotel for 3 months and he's been applying for jobs from day one since he entered. In fact, he's been applying for jobs even before he entered. What does the circumstantial evidence show? He never wanted to join that employer. So circumstances determine the intent. Okay?
You have to tell a story, right? Like what
Don't make
all
up
you
stories. Don't make up stories. These guys are fairly skillful. They'll catch you. Don't make up stories. And in fact, if you have a good lawyer, they should never ever file a case where they know it's a story. Okay.
Okay. Thank you for answering my question.
You're welcome. Good luck. Okay. So let's see. This one is from Texas, area code 817. Yeah, 817. I can hear you. Go ahead, please.
Hi, Rajiv. I'm currently on H-1B, and I just got married to a U.S. citizen, and I'm filing I-130, 485, and AP. My question is, can I enter the USA if I go to India on H-1B if I don't have an approved advance payroll by then? Will my family-based petition get abandoned if I do so?
Yeah. Okay. So here is the interesting thing. The fact that you can travel on a pending 485 with an H-1B visa in an employment context is clear. If instead of filing through your wife, you had filed through your employment, definitely you can travel without advance parole on H-1B visa. Can you do the same thing on your family-based petition? To the best of my knowledge, yes, you can. What should you do? Double check it with USCIS customer support once. Okay.
Okay. Just a follow-up question. In worst case, will my the worst case is I-485 get abandoned, but I-130 will be
it would still be processed and you can refile the I-485. No problem.
Got it. Thank you.
Right. You're welcome.
Thank you very much.
You're welcome. Good luck. Okay. Let's see. The next question is from Arizona. Okay, Arizona, go ahead, please.
Hello, Rajiv. My passport is expiring in February of 2024, and my H-1B is just to be filed this year. So that is like June 30. So in this case, what do you recommend? Should I renew my passport first, or should I go with the H-1B filing?
Well, what I would do if I were your lawyer, if I'm pressed for time and the passport is not coming, I would use the old passport and I would make a declaration on the paperwork that the passport is being applied or it's applied for already.
Okay.
All right.
So in that case, I have heard that the H-1B duration is based
No,
on
it should not.
expiry. So
It should not. I don't think so, because I've been in this situation before and I did what I just told you. We had our client apply for the passport, and using old passport and a declaration and even a copy of the application that has been filed, we were okay.
Okay, good. Thank you. Thank you, sir.
You're welcome. Good luck. The last question is from area code 567, which is Ohio. Ohio, go ahead, please.
Hi, Rajiv. Thanks for the call. So I was selected for DV visa 2024.
Oh, stop.
Currently,
Stop. I don't know anything about DVs, but if your question does not relate to DV, then go ahead.
Yeah, my question doesn't relate to DV. So what I did, I filled the DS-260 and then made a statement that I wanted to do adjustment of status here in US. I'm currently in OPT stem. And I decided to do consular processing. And for that, I emailed KCC. And KCC has not been responding properly. Like one time, first reply they told me my...
Hang on one second.
Sure.
You're trying to convert from counselor to from 485 to counselor.
Yeah, adjustment to counselor, yes.
Okay. That is not done through KCC. You have to file a form. This is a DV or is this the employment based?
I didn't pay the receipt.
Sorry?
It's a DV based.
Oh, DV. I don't know. Like I told you, I don't know anything about DV-based cases because we don't do these cases.
No worries.
But the normal procedure for other people, not DV people, but let's say it's an employment-based case, if we want to convert an adjustment to a consular processing, we have to file a specific form. I'm trying to remember what the number is. It's called application for action on an approved petition, something like that. I-840, I think. I think it's I-840. Okay. So double check that that's not what the process is for DV. I do not know what the answer is. Sorry.
It's the same process, but I haven't paid the, you have to pay some administration fee for
Hang on.
adjustment of status.
Let me confirm. I think it's I-824. I think I remember now.
I think so.
Yeah, I-824. Yeah, it is form I-824. That's what we file.
Okay.
Okay.
Okay. Yeah. But the thing is, you already told you don't do DV exact cases because you have to pay administration fee for adjustment of status, and I haven't paid that. I don't think I have to do I-824.
You know more about this than I do. So sorry. No idea.
Okay, no worries. Thank you so much.
You are welcome. Okay, I finished all the questions, but I still have about 10 minutes. If you have any other follow-up questions, go ahead and press *5 again. Let me get a second round in here while I still have some time. And okay, there's one more. Okay, there's just one more question from Texas. Yeah, Texas, go ahead, please.
Hi, Rajivji. I think you just answered my question about traveling on advance payroll while family-based petition is pending.
Right.
I had a follow-up question. I wanted to ask can I go for H-1B stamping when I'm in India while my I-485 family petition is pending?
Absolutely.
Okay.
Absolutely.
Okay.
Okay. Good luck. I think we have a lot of people from Texas today. Another question from Texas. Let's get that. 1 second. Texas, I can hear you. Go ahead, please.
Hi. Another follow-up question. If he has H-1B approved, if he goes...
Ma'am, are you the fiancé lady?
My name is...
Are you the fiancé lady?
Yes.
Okay, go ahead. I remember.
Sorry.
I remember.
Yes. So he has the H-1B approved. If he goes for H-4 visa, will he have any difficulty in the H-4?
No.
Because he has H-1 approved already?
No problem. No problem.
Okay.
All right. Good
and
luck.
Then on the previous question, on the previous question, you said he can search for a job on H-4 and then as soon as the company does the H-1B transfer, he can start working. He doesn't have to wait for H-4 EAD, right?
No, I didn't say that. I said he can look for a job while he's on H-4. Then the company will apply for H-1 transfer back to H-1 or change of status back to H-1. And then he has to wait until the approval comes before he can start working.
Okay.
Right.
So EAD, we don't have to wait until EAD.
Well, do you have your I-140 approved? Are you past the 6th year of your H-1B? What is your situation?
Yes, I have I-140 approved.
Then you can do both. You can file for his EAD also, especially if you can, EAD is going to take a long time. But yeah, you can apply for his EAD as well as if he gets his job offer, he can apply for an H-1. Forget about the EAD if he gets the H-1B then. Because the EAD is going to take a long time. Okay?
Right. We don't have a premium processing
Not
for
yet.
EAD, right?
Not yet. Not unless it's a certain, very particular set of circumstances. Otherwise, you can't. Okay?
Okay.
Good luck, ma'am.
Thank you.
You're welcome. Okay, folks. Great hanging out with you. I'll see you next week on LinkedIn. Bye-bye.